Welcome to today's webinar. My name is Ed Redder. I'm a partner in Thompson Hine's Employee Benefits and Executive Compensation practice in our Columbus office. I'm joined today by my colleague, Amy Gerbick from our Cleveland office. This is the second installment of a four-part webinar series that will provide an overview of fiduciary obligations for health and welfare plans and deep dives into specific fiduciary issues. Today, we will address the plan document and addressing requests for exceptions, selection and monitoring of service providers, and evaluating plan fees and provider compensation. Before we begin, a few housekeeping items. Today's program is being recorded and we will send a link to all attendees, including the PowerPoint, within 48 hours of today's presentation. If you have any questions during the webinar, please feel free to use the question box located in the control panel on the upper right side of your screen. We will answer as many questions as we can at the end of the webinar. Thanks again for your interest, and we'll now begin.
So good afternoon, everyone. Hopefully you all had the chance and the opportunity to attend the first seminar in our series a couple weeks ago. In that webinar, we did provide a refresher on the fiduciary obligations that apply to health and welfare plans. We covered topics such as who is a fiduciary, and then what are the basic fiduciary duties that apply to these plans, which you can see listed here on the slide. That webinar also introduced some of the reasons why we are now starting to see an increased emphasis on health and welfare plan fiduciary obligations, including the fact that we've seen a number of complex rules and regulations come out governing health and welfare plans. For example, HIPAA under the Mental Health Parity Addiction Equity Act. We've seen a number of rules come out, and of course the Consolidated Appropriations Act. A number of these rules and regulations have been specifically designed to provide increased transparency, both to health and welfare plan fiduciaries and to plan participants, which is a good thing, but also because fiduciaries and participants now have increased access to cost and pricing information. The fiduciaries are expected to use that information to help evaluate and control planned expenditures. We also are seeing increased scrutiny by regulators on compliance issues and on the requirements under those new rules and regulations. And of course, we're starting to see an increase in litigation, particularly around plan costs and fees. We've listed here on the slide a number of types of fees that have been the subject of recent lawsuits, and we expect that there will be more to come, which is why this is such an important issue, and it's important for health and welfare plan fiduciaries to make sure that they have the correct policies and procedures in place to carry out these obligations and protect themselves. So today's webinar, we hope to dive a little deeper into three of these specific duties applicable to health and welfare plan fiduciaries. First, we're going to take a look at the duty to follow your plan document, including a discussion of what to do when you receive those inevitable requests for exceptions. We're also going to look at the duty to prudently select and then monitor any service providers to the plan. So I'm going to turn it over to Ed to talk a little bit more about the duty to follow the plan document.
Excellent, thanks, Amy. Yeah, so as Amy previously highlighted, plan fiduciaries have a duty under ERISA Section 404 to act in accordance with the plan documents and instruments governing the plan, as long as they're consistent with the provisions of ERISA. And that obligation, of course, raises the issue of what is the plan document. And so kind of the preliminary issue is to understand exactly what the plan document is, which is seemingly a pretty straightforward process, and oftentimes it can be, but not in all circumstances. And so just again to revisit, ERISA Section 402 also says that every employee benefit plan must be established and maintained pursuant to a written instrument, and that such instrument shall provide for one or more named fiduciaries who are jointly and severally have the authority to control and manage the operation and administration of a plan. But then ERISA doesn't really speak in a lot of detail about what exactly that plan document has to say. In contrast to the SPD requirements, right? We have statutory provisions under ERISA that discuss the content of SPDs. We also have detailed regulations and additional guidance that get into the content and kind of the form and style of what an SPD has to do. And those SPD content requirements are actually quite elaborate and specific, and go into basically require that the SPD detail all the conditions for eligibility for benefits and limitations. And so if an SPD is intended to be a summary of the plan document, then it certainly goes hand in hand that the plan document ought to touch on those topics. And so really the plan document should comprehensively set forth the plan's rules, including the definitions of plan terms, detailed descriptions of employee and dependent eligibility rules, covered benefits, exclusions, plan governance, and handling of plan assets, if applicable. Next slide, please. So as I mentioned before, it can sometimes be quite difficult to ascertain what constitutes a plan document. And in my experience, there's actually significant confusion around this point, or there can be. For instance, I get involved in M&A transactions on occasion, and when we request documents, we often see posted an SBC, a summary of benefits and coverage, right? Which is a very short summary of a medical plan's terms. It certainly is not an SPD and absolutely is not the plan document. And you go to the other end of the spectrum, and we often have wrap plan documents and wrap plan SPDs, which incorporate a variety of different health and welfare benefits under or within one plan document, and eases the administration from that perspective. Between those 2 points, we often see separate plan documents and separate Form 5500s filed for those plan documents for distinct benefit types, say life insurance, medical, dental, vision, right? A variety of different health and welfare benefits. Oftentimes we see companies rely on insurance certificates or vendor provided booklets. We also quite frequently see reliance on SPDs as both the SPD and the plan documents. And one of the concerns we often have and actually find issues with is conflict among those documents. And we also find that the provider documents, such as insurance contracts and benefit booklets, often don't contain all of the required provisions. One I see very frequently is in eligibility provisions and benefit booklets, right? We engage a third-party administrator. The third-party administrator generates a benefits booklet that describes a lot of the terms and a lot of the provisions governing the benefits that are offered, including exclusions and covered services and other details. But when it comes to eligibility, I've often seen the benefit booklet merely say, yes, you're eligible pursuant to rules and procedures established by your employer. And so, which doesn't offer a whole lot of detail or guidance on who is eligible. The other gap that we often see in provider documents or in certificates is information regarding the plan name, number, plan administrator, and trustee. Some of the very basic information that the SPD is required to have. And so, I guess long story short is it's important to gather the documents that are intended to act as the plan document and make sure and confirm that they contain all the required provisions. And so as I mentioned when I first started discussing this slide, to address various gaps that we see, we also often recommend adopting a wrap plan document and a wrap plan SPD. There's a lot of benefits to this approach. You can incorporate the various health and welfare benefits under a single ERISA plan, streamline administration. You could file a single Form 5500 rather than various Form 5500s for the plan, the wrap plan. And one of the keys though is to make sure that those documents, the wrap plan documents, and the incorporated benefits are consistent as well, right? You don't want to have default provisions that are inconsistent with other provisions that are in the incorporated underlying documents.
So we know that we're required to have a formal plan document under ERISA, and we know that you're required to have a summary plan description, which describes the terms of the plan. One question that comes up from time to time, I think, is whether or not you can have both of those, or one document that serves as both the formal plan document and the SPD. There is some risk associated with combining both of those documents into one single document. There have been courts and commentators, in particular, I believe there's a Supreme Court case, Cigna versus Amara, where there was a view expressed that a combined document and SPD would not work because it's not possible to have a document summarize itself. However, there have subsequently been some appellate courts which have said that it is possible to do that you can have one document and that's okay. So as a health and welfare plan fiduciary, I think when you're considering what to do with your plan documentation, you just need to be aware that there is this risk exists and address it accordingly. There's some advantages to having these documents combined. Ed mentioned inconsistency in your plan documents, and I'll talk about that a little bit more on the next slide. But if you have everything in one document, you eliminate the risk of having inconsistencies. You have all the plan terms contained, so that streamlines documentation. It also helps eliminate the risk that you're going to have problems with your confusion in your documents and problems with your participants. Also, the SPD requirements state that you must draft your SPD in a manner that it should be easily understandable by a plan participant. So sometimes it's a little different, I guess I would say. Retirement plan documents, when you have a formal retirement plan document, they tend to have a lot of technical legal requirements, and SPDs are used to try to make that easier to read and summarize that information. Health plan SPDs are a little bit different. They tend to contain a lot of technical legal requirements. I mean, in particular, they will have all the different covered benefits, the exceptions, and participants need to have that information in order to exercise their rights under the plans. Typically, I think in my practice, what I've seen is that health and welfare plan documents are not always more difficult to read than an SPD. But it's a consideration. So if you're going to have one document, you just need to really make sure that that document is able to be easily understood. You also want to make sure, and maybe this is obvious, but you want to make sure that if you're combining the documents, that you are satisfying all the rules with respect to plan document requirements and those SPD rules with respect to format and content. You have to have all the necessary pieces in that one document. So we mentioned consistency. There we go. It's vital that all of your health and welfare plan documentation be consistent. I think particularly in the health and welfare benefit plan context, there are usually a number of documents that describe the terms of the plan. You have your formal plan document, your SPD, you have those summaries of benefits and coverage, certificates of coverage from providers, enrollment materials, and having a lot of documents which describe the terms of the plan can inevitably lead to inconsistencies. So a best practice that we would recommend is for plan fiduciaries to really establish and document a set procedure to review their plan documents and all their plan documentation, maybe on an annual basis, so they can sit down and compare the terms, make sure that everything is consistent. You know, I think a lot of times plans can go on autopilot, and the administrative practices are not always, you know, don't always remain consistent when changes are made to the plan documentation. So in addition to looking at the documents, you should also make sure you're comparing them with the actual administrative and operational practices that are being used to administer the plans. That's an important piece, and that can help minimize the chance that you have a lawsuit down the road.
Yeah, Amy, just to add to that, and that's exactly right. One thing that I've observed in reviewing plan documents in this space and working with TPAs is that the TPAs will often refer to what they call kind of a source of truth document, which is kind of internal guidelines that the folks internally are processing claims based on, right? And so I think it's also important to, if you have access to those documents, that you should, to get copies of those documents to ensure that those documents are consistent with what the plan document and SPD say as well.
Yeah, I think that's a very good point, Ed. You know, in my practice, I've seen a lot of times those documents are kind of set in stone when you first engage the service provider, and they don't often get revised when you are making changes to the plan. So it is always a good thing to go back and look at those. Next, we wanted to talk a little bit about requests for exceptions. And when Ed and I were sitting down to talk about this presentation, we kind of felt like exception requests fall into two categories. One is a request made with respect to a benefit determination. And this would be where you have a participant who has needs a procedure or treatment or maybe a drug, and it's not covered under the terms of the plan. So they're asking you, hey, can you go ahead and cover this even though the plan says it's not covered? These requests can be tempting. They can also often be sympathetic. I mean, a lot of times, at least what I've seen in my practice, is that when people are asking for an exception, it's usually because the specific treatment or procedure is costly. Sometimes it depends on, you know, you have a high executive or a high person up in your company who is making the request, and that can be challenging. You know, they want that exception, and what do? It puts you in a difficult situation. But as a health and welfare plan fiduciary, you need to be wary of making exceptions when they are contrary to the plain terms of the plan, because that could be a breach of fiduciary duty. And there's a few considerations that you should take before making a decision. You know, the first that we have listed here is that any exception to approve a non-covered plan benefit is setting an ERISA plan precedent, which technically requires you to then offer that similar coverage to any similarly situated employee or participant. If you don't do that, then you are opening yourself up for a potential claim for ERISA breach of fiduciary duty if any of those similarly situated employees, you know, are subsequently denied coverage for the same treatment. One thing, you know, you could consider if you are sympathetic and you are looking to, you know, want to do something to help this person, don't do a one-off exception. You know, consider whether it is appropriate to change the terms of your plan. You know, I think that you could, you know, look at the coverage and see if that's something you want to adopt for all of your participants, and then adopt a plan amendment if that seems appropriate. But don't just make a one-off exception. In addition to the ERISA plan precedent considerations, you also want to make sure that you, if you're considering this, that you take a look at any agreements that you have, if you're self-insured with your stop-loss provider, or if you're a fully insured plan with your insurance carriers. It's not uncommon that those agreements will contain limitations in them regarding exceptions, and if you were to grant one, those providers could deny coverage, and then the plan would be on the hook for paying for that claim.
Yeah, and Amy, just on that point, I would just add that, you know, so many of these requirements seem technical in nature and don't seem to carry much risk. But I would say that the last point you made on the stop loss carriers, that's a really strong exception to that case, because I've actually had a couple of different experiences in my practice over the years where that very type of conflict arose and the stop loss carrier declined the coverage. And so it's a real risk, and certainly if you have stop loss coverage in the background, you'd need to be sure that that you're following the plan's terms or run that risk. And as we all know, those claims and costs can be astronomical depending on the type of condition that's involved.
Yes, that's definitely true. So another consideration that a fiduciary should undertake is the potential that you could lose your deferential Firestone standard of review if this exception, eventually results in a claim being brought in a federal court. Plans all contain claims and appeals procedures, and it is the responsibility of those named fiduciaries to make those determinations with respect to benefits coverage. So if an employer is making the decision to override a determination made by your named fiduciary, that could, result in the loss of the standard, which is not something that you want to happen should this, escalate. Another consideration, I guess I would say, and I've seen this happen in my practice, is, you make all these arguments and you have an understanding that, we can't make an exception under the terms of the plan because there's a lot, potential negative consequences. But why can't we do something outside of the plan? Can we perhaps do a bonus of some sort to help alleviate this person's, issues, this participant's issues? And I think you need to be mindful if you get that type of request as a fiduciary that any attempt to reimburse a medical expense, which occurs outside of your traditional group health plan, could wind up in you inadvertently creating another group health plan. And then in that case, you would need to be complying with all of the various requirements under ERISA and COBRA, et cetera, with respect to this new group health plan that you've created. So you need to be careful in those situations. So there's some good news. I guess if the plan terms are unclear, as a fiduciary, you do have the ability to interpret the terms of the plan. So, maybe somebody is coming to you with an exception and it's because the terms are a little ambiguous. The fiduciary is within his rights to interpret those terms. You just need to make sure that that interpretation is reasonable, that it's then applied consistently, and that you document that. And you want to make sure that, it's the named fiduciary responsible for your claims and appeals who is making that interpretation. Okay, so the other category of exception requests that we wanted to talk about are your mid-year election changes. Everybody knows, I think, that the general rule under Section 125 is that for a health and welfare plan election to pay a premium on a pre-tax basis, if that for that to stand, the cafeteria plan, under a cafeteria plan, you have to make sure those elections are made prior to the start of a plan year, and then they have to be irrevocable for the duration of the plan year, unless the participant experiences one of the permitted election change events. If you do allow employees to make mid-year pre-tax election changes, you could run the risk that your plan would violate that irrevocable election rule, and that the entire plan could potentially lose its tax favored status, which would result in all of the elections becoming taxable to employees. And that is definitely not a result that anybody wants to have happen. There is perhaps a little more flexibility with mid-year election changes than we saw with benefit determinations, and that IRS officials have informally endorsed a doctrine of mistake in this context that does permit a late election change once the plan year is started, as long as you have clear and convincing evidence of that mistake. There's a high standard of proof associated with that clear and convincing evidence. The example that Ed and I discussed when we were putting this together is, the unmarried participant who doesn't have any dependents who elects a dependent care flexible spending account for the year, and then probably notifies the plan administrator once they see that they're having a deduction taken out for that. That's something that you can pretty clearly point to as a mistake, and that you could provide clear and convincing evidence and allow that person to make a change to their election. I think where you need to be wary is when you get the participants that come to you with the, I meant to elect this, or I meant to do that, and you don't really have any evidence of that, then you need to be a little more suspect. In addition to the cafeteria plan consequences, election changes or exceptions made for mid-year election changes can also result in you establishing an ERISA plan precedent. Just like with the benefit determination changes, creating that precedent allows or requires you to make sure that all of the other employees who have similar circumstances are treated in the same way, and potentially would require you to open up your open enrollment and allow all of your participants to make post open enrollment changes. And I have actually seen that happen in my practice, and that administratively is not it's not desirable and can be very difficult. Again, on the plan provider side, if you have a fully insured plan, you'd want to make sure that your documents with your insurance carriers would permit election changes outside of the enrollment period. Similarly, with a self-insured plan, your stop loss agreement. So similar to the benefit plan determinations or benefit determination exceptions. And I think that brings us to the end of our discussion on the duty to follow your plan document. And next, I'm going to turn it back over to Ed to talk a little bit about the duty to prudently select and monitor your service providers.
Yeah, thank you, Amy. And I do want to note that I see a few questions that have been posted thus far. So why don't we try to address those quickly, Amy? One is state in regards to exceptions, what about when a plan is silent on a specific procedure or service? And I guess my thought is that if a plan is silent on a specific procedure, I mean, generally the plans describe and will detail the specific services that are authorized, right? And then there are a number of exclusions. So I suppose in that circumstance, if a service isn't noted as covered, then it would not be covered. Amy, any thoughts on that? Any difference of opinion?
I mean, I would agree with that. I mean, I think in that case, you might have a little bit of flexibility to make an interpretation as a plan fiduciary, since it's somewhat ambiguous, but I would agree that I would lean towards, a determination that it's not covered. You can always consider whether or not it's something that you want to amend the plan for going forward and make it a formal change.
Yeah. Excellent. Thank you, Amy. So let's dive into our next topic at this point, and that is the duty to prudently select and monitor service providers. So we have a couple of obligations that are kind of driving this duty. One is under the general fiduciary obligations of the plan administrator and fiduciaries to act prudently, right, and consistent with the standard of care set forth in ERISA. And so the selection of a service provider for a welfare plan is an exercise of discretionary authority or control over the management, and therefore would fall within a fiduciary act subject to your fiduciary duty of prudence. Beyond that, we also have very broad, let's go to the next slide, Amy.
Oops, sorry, wrong direction.
That's okay. We also have, very broad prohibited transactions. So under ERISA section 406, an engagement by a plan of a party in interest which would include a service provider, to provide goods, services, or facilities is, for a fee, is considered a prohibited transaction. And you step back and say, boy, that seems exceptionally broad. Wouldn't that prohibit all engagements? Well, ERISA paints with a very broad brush on the prohibited transactions, but similarly, the prohibited transaction exemptions in certain circumstances also are very broad. And what would apply here is Section 408B2, right? That provides that an arrangement with a service provider is not prohibited if the contract or arrangement is reasonable, the services are necessary, which has been interpreted to mean appropriate and helpful for the establishment or operation of the plan, and no more than reasonable compensation is paid for the services. There are also specific disclosure requirements that have been adopted and enacted within 408B2 for providers of brokerage or consulting services. And I would just step back for a minute and note that consulting services are defined very, very broadly under Section 408B2, and certainly could reasonably be read to encompass services provided by TPAs and PBMs in a lot of circumstances. What will probably not surprise you, though, is that the TPAs and PBMs largely disagree with this reading and take the position that they're not providing consulting services. And so it really is important to understand the position of your TPA and PBM and other service providers on this issue and document it. But I would also say, though, even without application of those specific disclosure requirements, those engagements are still subject to the prohibited transactions. And if you're relying on Section 408B2 of ERISA for an exemption, then you're going to need to gather the information in order to make the determination that the contract is reasonable, that the services are necessary, and no more than reasonable compensation is paid for the services. And again, that seems straightforward and easy to do, but in practice it can get pretty complicated. There are all sorts of fees connected with health plans. Certainly, we've seen a variety of kind of shared savings programs and prepayment analysis and recovery services that really run the gamut and could provide for additional payments beyond really just the base administrative fee that's paid under the contract. So one of the real challenges, even though these steps seem fairly simple, is to really get your arms around exactly what the services are that are being provided and understanding the compensation so that you can make a determination of whether it's reasonable or not. Next slide, please. So that really raises, how do we go about doing that? How do we select our service providers? And that's where really the request for proposal process comes in. We recommend to our clients that they satisfy their fiduciary obligations and document their compliance with the exemption through, in part, conducting periodic RFPs for services. Generally, the time frame we recommend is every 3 to 5 years, so it's not cast in stone, that you go out and solicit proposals for welfare plan services, including TPAs, PBMs, brokers, and consultants for that purpose. Now, I would also say that I often get pushback of, boy, it's expensive to do that. It's time consuming to go through the RFP process frequently. And boy, can't we just rely on benchmarking data? And I would say, yes, benchmarking data can be valuable and it can be helpful in, confirming the reasonableness of fees. but it really, from my experience, is not a replacement for going through the full RFP process. You know, I've noted in a variety of circumstances where it's taken a full RFP to move the needle, to get additional services or enhanced services, or to reduce fees that are being charged. And simply benchmarking is not going to do that. But again, it can be of value kind of between the times that you conduct full RFPs. Another item I'd note is that if you're using a third party to run the RFP process, and that's often the case, you really need to consider any conflicts of interest that that entity has, and particularly how they're compensated, right? So if you're working with a broker or a consultant and they're assisting in soliciting bids and identifying potential service providers, make sure you understand how they're being compensated. Oftentimes there'll be a statement of work for that sort of project that will clearly identify compensation that's being received directly, but understanding if there's any additional compensation changing hands in the background, such as commissions from the winning provider, I think is critical as well in that process. Next slide. And so when we go through the RFP process, we really want to implement and document a formal service provider selection process. And that formality can be important, right? Because we want to make sure that when we're sending out requests to multiple vendors that could be potentially selected, that we're applying a level playing field, right? Everybody's getting the same request, everybody's being asked the same questions, and we're getting kind of complete proposals from each of the parties, right? And so the first point is getting information from multiple service providers. It's really difficult to determine whether your arrangement is reasonable if you're just negotiating with one vendor, right? You don't have any sense, you don't have the context, you don't understand what's available in the market and the rates that are being charged in the market. And again, this changes over time and quite frequently. And so it's important to get information from multiple service providers so that you can then step back and say, boy, okay, now we have three to five vendors that have provided proposals. We can now assess the reasonableness of the fees that are being proposed. Again, compare providers based on the same information, such as services offered, experience, cost, business capacity, technological expertise, et cetera. So again, this goes back to that formality of process, right? Cover all the bases that you want, but make sure that you're doing so on a consistent basis with the different vendors, and so that you understand each of their capabilities when you're assessing which one you'd like to select for the plan services. Obtain information about the provider, including financial condition and experience with plans of similar size and complexity. This is also important, right? There are a number of smaller kind of startup organizations in the market that are trying to grab business and attract business. And that's great, but you have to be a little wary of their level of experience, their sophistication. Do they have other clients that are similarly sized to your plan, with same numbers of participants and beneficiaries and members? Do they have that bench strength to be able to handle that additional business? And then if something goes south, are they going to stand by their obligations, and are there going to be resources to satisfy any claims you may have against that service provider? So it's really important to understand the vendors that you have and their financial condition and ability to conduct the business that you need them to conduct. Evaluating the quality of the provider services. Again, it's important to understand, how have they been rated? How are they viewed by current clients? If possible, get references. They may provide references to plans that are similarly sized, and you can discuss those and at least make calls to folks who are utilizing their services currently. Last one, evaluate the privacy on this page, evaluating the privacy and security, including cybersecurity policies and practices of the provider. So we all know, or most of us know, that this is a real focus of the regulators now, and for good reason, right? We see news on an almost daily basis of hacks and intrusions and other, unauthorized uses or disclosures of sensitive information. And I would say, we do have the Department of Labor issued good guidance and recommendations a few years ago in the retirement plan space about selection of vendors and working through kind of their privacy and security policies and practices. And while those best practices were focused on retirement plans, they really do have kind of application in the health and welfare benefit setting, recognizing that, for group health plans, we also have the overlay of HIPAA and kind of all the requirements that go part and parcel with that as well. Next slide, Amy. So in addition to the previous points, it's valuable to identify any recent litigation and enforcement action against the providers. If you're going with a larger provider, quite often you'll see headlines about those providers. So it's important to understand why they're being sued, right? And kind of understand where there may be pitfalls out there, just to understand how solid they are as a provider, ensuring that any required licenses, ratings, or accreditations are up to date. Identifying any conflicts of interest with the provider. And this, again, goes back to a couple slides ago when I talked about understanding the compensation model. And unfortunately, I think it's becoming more and more difficult at times to really tease out all of the potential avenues of revenue and fees related to a number of service providers. I feel like this is an area where there's been a lot of improvement over the years in the retirement plan space, but we haven't seen kind of the consistent improvement, despite a lot of efforts, I think, in the health and welfare benefits space. So it's important to probe and understand what that compensation is, because again, it's a prerequisite to determining the reasonableness of compensation to understand what that compensation is. Next point, reading, understanding, and keeping a copy of all contracts. Yeah, but even before we get there, right, and that's important, certainly, it's the negotiation of the contract, right? Getting a sample of the contract that they use. Because I think what I've experienced, and I'm sure what others have experienced, is there's oftentimes a real disconnect between what the sales team from the vendor tells you and then what the contractual provisions say. And it's important to make sure that those contractual provisions are, first of all, they comply with law, and also that they provide the protections to the plan that are necessary for you to enforce your rights. One common area where we see a lot of problems is in the audit rights, right, of contracts and claims. And it could be a difficult area to negotiate over with vendors, but I think it's important to get the best possible provisions in the agreement as you possibly can. And then last, confirming that each provider handling funds is bonded. And then last bullet on this page, and I can't underscore the importance of this enough, but it's maintenance of records of the RFP process to defend against potential claims of imprudent selection of a service provider. We always say it's process, 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 but it's also documenting that process. Because if you don't have documentation of the process you went through, it didn't happen, right? Or at least folks could argue that it didn't happen and could disagree and argue that, no, you didn't go through that process, or you can't tell us the details of the process that you went through, and memories fade, right? So again, it's critically important with along with a lot of other aspects of kind of fiduciary governance, to document the process that you went through and save that in the event you're ever challenged on the selection of a service provider. Then Amy, I'll turn it back to you.
Okay, thank you, Ed. So you've now gone through your RFP process and you have engaged a service provider to the plan, and your job is done as a plan fiduciary, right? Unfortunately, that's not the case. There is a separate duty to monitor your service providers once you have engaged them. The plan fiduciary is required to monitor performance of all of the service providers in order to make sure that the services are being delivered as they have been agreed to in the contract that you signed, and also that the services provided and the fees charged are and continue to be reasonable. So a best practice that we would recommend is that similar to what you would do for an RFP process, you should establish and document a formal provider review process, to go through maybe again on an annual basis to ensure that all of your plan service providers are performing their agreed upon services. That process should include a review of the provider's actual performance against any contractual performance guarantees. Make sure that they are actually doing what they say they are going to do in the agreement. Similarly, make sure that you're being charged the fees that are the fees listed in your agreement. It makes sense to go back and take a look at that and make sure that that's happening. You want to review any updated policies and practices of the service provider. Maybe take a look at their maintenance and retention of plan records. Make sure that they are following the procedures that they have promised to provide. You also want to maybe follow up on any participant complaints that have occurred in the last year with your service providers. These can be kind of warning signs that there might be trouble with your service provider, or that the services aren't being provided in the manner that you assume they should be. So take a look at that. And then again, just general adherence to any of the contract terms. And you want to make sure that you document all of this. So as Ed pointed out with the RFP process, that you have evidence of it, and that you can point to that in case you ever have a claim brought. Another consideration when you are looking at vendor performance is considering whether or not to do a claims review. Ed mentioned that when you're entering into a new contract with a service provider, we do spend a lot of time looking at those provisions in the agreements and making sure that the plan fiduciaries have the right to audit claims. So you want to make sure as a plan fiduciary that you are doing that on a periodic basis. And if you need to, go ahead and hire an independent auditor to help you with that. And as part of that, make sure that your service providers are granting you access to all of your claims data. One thing we wanted to mention here is that the DOL did recently conduct a webinar series on fiduciary duties, and in that webinar, they noted that plan fiduciaries should not agree to contracts in which the vendor limits the plan's ability to access data that would be necessary to monitor a vendor's performance. I mean, we have these the requirement now that the contracts don't contain any, gag clause provisions that would restrict access to this data, but this sounds like there's also an obligation on the part of fiduciaries not to enter into any contracts, or at least that the DOL expects that you don't enter into any contracts in which there is a limit on the ability to get access to your claims data. Another thing that you want to continue to monitor with your service providers is the reasonableness of your arrangement. So I think this in particular comes up maybe when you've had a service provider who's been your provider for a long time, things have been running relatively smoothly, so you maybe don't consider, making a change. However, you should be mindful as a plan fiduciary that your engagements are not set it and forget it. And this is where benchmarking can be particularly important. You want to consider whether to engage somebody to go out and benchmark the services to make sure that the engagement that you have with your service provider is still considered to be reasonable in the market. You want to make sure that you go through that process, document any determination that the fees continue to be reasonable and necessary for the plan's operation and not excessive for any of the services provided. You want to make sure that you are continuing to ask for and receive those 408B2 fee disclosures and reviewing those as part of your monitoring process. And I think that, unless Ed, did you have anything that you wanted to add with respect to monitoring?
Yeah, Amy, I would only add that this kind of brings it full circle back to the contract terms, right? It's, we want to make sure we have very clear contract provisions. We want to have, we want to make sure that the contract provisions, again, don't restrict us in our ability to get that information, and also that they're clear. I mean, I see it happens so many times that you look at performance guarantees and you look at other contractual provisions, and there's really just not a lot of clarity, and it leaves room for argument. And then I would also say on the performance guarantees, those are always kind of an interesting area to explore because I've noted on many occasions, and most occasions I would say, that the performance guarantees are largely measured by the vendor themselves, right? And so you kind of step back and ask yourself, well, are they going to rate themselves poorly? Are they going to provide data that shows that they failed in their performance guarantees? I mean, maybe, but it's also good to have the ability to check them on the performance guarantees and have objective measures that you really can confirm, because there's again, it's really left with the vendors in a lot of circumstances. So we have a few minutes left, and I see that there are some questions, and let me. So one question, how long would you recommend saving the records and documentation of an RFP? Thoughts on that, Amy, before I jump in?
I think that you would need to save them probably the same number of years that you're required to save any of your ERISA plan documentation. And I think off the top of my head, is that 6 years?
Yeah, I think from an ERISA fiduciary perspective, right, you'd want to have those records, because I believe the statute of limitations for a fiduciary breach would be 6 years. So I think at a minimum, we'd want to retain those records for 6 years, but certainly longer would be fine as well. Let's see. I'm sorry, I'm reading through some of the questions and seeing if I can articulate them well here. Yeah, I'm not sure I understand a few of these. One is, here, let me just read this, Amy, and you can share your thoughts. Correct me if I'm wrong, but my understanding is section 125 doesn't allow a change in the pre-tax election, but you can allow changes in coverage if the medical plan so provides. So carefully designed, you can permit mid-year changes in coverage so long as you don't allow for any change in pre-tax contributions as elected under the cafeteria plan, right? I think what they're getting at is, and I don't think that's accurate, but is that, you can make changes to the underlying benefits, but you can't change your pre-tax election for that benefit. And the cafeteria plan regulations certainly have provisions that allow for certain kind of mid-year changes under the cafeteria plan regulations. So, my view of that again is that yes, you could make certain changes. Now, there are situations where you may not be able to make a Section 125 change, but you could change the underlying benefit. But that's probably getting into a lot of detail that we don't have time to get into. Amy, any additional thoughts you want to pose on that?
Yeah, I mean, I think that I'm not sure I fully understand the question, but I think you're right. I mean, I think there are, I mentioned permitted election change events under the rules that would allow you to make changes, but I don't know outside of that what they're referring to.
No, and we may we'll try to follow up with you as well, just to make sure that we are understanding the question and can provide more valuable feedback, hopefully. And I don't, not sure I understand. So if you've posed questions and I haven't read them, we will follow up with you on your questions to make sure that we have a good understanding of the question and we can properly respond to it. But with that, I think we're at the end of our presentation. Thank you all for joining us today. As mentioned earlier, within the next 2 days, you will receive a follow-up email with the recorded webinar and presentation slides. You can sign up for the remaining webinars in this series through the invitation you received or on our website. Our next webinar will focus on prescription drug-related issues and is April 24th at noon. Again, if you have questions that we did not get to today, please email or call your regular Thompson Hine lawyer. If you are not a current Thompson Hine client, please contact me to discuss available options that we will address, and we will address your needs. Enjoy the rest of your day, and thanks for attending.
Thank you, everybody.